I am Barrister Mohammad Fariduddin, and today I will mainly discuss about the definition and types of constitutions. Constitution can be defined in two main ways or from two different perspectives. First, it means a written document of rules prescribing the compositions, powers, and functions of the main institutions of any country, and also prescribing the relationship between that country and its people. These types of constitutions are called written or codified constitutions because a single piece of written document contains most of the constitutional rules, and that single piece of document called constitution gets supreme legal status and gets extra legal protection. For example, Bangladesh, India, Pakistan, etc. have written constitutions. Depending upon the countries, the size of the written constitution can be large or very small. For example, the Constitution of Bangladesh contains 153 articles, whereas the Constitution of the USA contains only 7 articles. The life cycle of a written constitution or codified constitution includes its birth, amendment, and death. The birth of a constitutional text may be stimulated by various factors, including independence, war, revolution, or peaceful transition of political powers. A body known as Constituent Assembly that is dissolved once the text is agreed typically carries out the process of drafting a constitution. Then the draft text is formally adopted as a country's constitution after it has been approved by the people in a referendum, or sometimes it is deemed that the people supports the constitution without any referendum. Sometimes the codified constitution may require amendments to meet the current social attitudes or to address technical issues regarding state power. For example, in May 2005, the Irish constitution was amended to insert the words that marriage may be conducted in accordance with law by two persons without distinctions as to their sex, which was approved by 62% voters in a referendum. 100 years ago, passing of such referendum was unimaginable, so the social changes is required to be cope up with the amendment of the written constitution. A written constitution may come to an end in several ways. A ruler may illegitimately seize the government power and suspend the constitution. The constitution may also end in a more legitimate manner. For example, in 1958, the Fourth Republic of France was dissolved following a popular referendum. A written constitution represents a form of law superior to all other laws of the state. Here state means a country. Any law in conflict with the constitution are liable to be declared unconstitutional and void by a court of law, typically a superior court of law. The task of determining the constitutionality of legislation is often assigned to superior court often prescribed by the Constitution itself. Such courts decide disputes between the organs of their state and also between the state and the citizen. The constitutional powers and functions of the state organs or institutions, the constitutionality of any law, and the constitutional validity of any amendment of the Constitution, etc., are also decided by such superior courts. It means that the legislature does not have the unlimited power and may legislate only within the limits imposed by the Constitution itself. Therefore, the Constitution sets limit both to the powers that can be exercised and to the manner in which those powers may be exercised. Written constitutions are important for indicating what actually happens in practice. But regardless of the length and complexity of the written constitutions, it is highly unlikely that they will contain all the answers to all the questions because of human beings' limitation of powers to foresee every situation. Where a written constitution is silent on a particular matter, the lacuna will be filled by custom, convention, common law, etc. In United States, the Supreme Court acts as a guardian of the Constitution. But this role was not allotted to it by the Constitution itself. The court confirmed its own role in Marbury versus Madison in 1803. However, later written constitutions of other countries expressly grant such role to their own Supreme Courts. Again, Article 2, Section 1 of the United States Constitution, together with the 12th Amendment, says that for the election of the President, the people shall choose electors who shall meet and elect by a majority whomsoever they will. However, in the United States of America, the presidents are elected as a matter of convention by a direct election rather than the indirect election as was prescribed in the Constitution. Therefore, convention plays an important part in the written constitution as well. From the second perspective, a constitution is not a single written document, but can be defined as being a system of rules. These rules establish the main institutions, determine how those institutions are to interact and coexist within the system, and define the relationship between the state and the people. These types of constitutions are called unwritten or uncodified constitutions. For example, the United Kingdom does not have a single document called the Constitution of the United Kingdom. But it has constitutional rules dispersed in various legal and non-legal sources. Unwritten does not mean that in the United Kingdom no constitutional rules can be found in writing. It only means that no single written document represents the Constitution in its entirety. Many of the constitutional rules can be found in various written laws scattered in various sources of various generations.